Justices of the Appellate Division Court Department, hear ye, hear ye, hear ye. All persons having business to do before the court and draw near and give their attendance and they shall be heard.
All right, have a seat, everybody. Hope it's not too cold for you out there on your way here. All right. The first case that we have for argument this morning is case number 995, People versus Jason Washington.
Good morning, Robert. This is Paul Robert on behalf of Jason Washington. And I apologize to the court. I now have a full-blown cold and I'm not,
Shocking in this weather.
yeah, I'm not feeling well. I thought I could do this and I apologize to the family too. I don't know why I'm here, but it's for the family and Mr.
Regardless,
Washington.
you had submissions, you had a brief.
Yeah.
We pretty much know what your argument is, so.
Thank you. Please consider the argument in the brief, especially the justification defense. If there's no questions, I'd rest on the brief.
Okay, and
Thank you.
hope you feel better.
Thank you.
Your Honor, seeing as defense counsel rested on the brief, if you don't have any other questions, we would just state that we believe that the people proved beyond a reasonable doubt or disproved beyond a reasonable doubt defendant's justification theory. I would only highlight 4 quick things so we can get defense counsel out of here if possible. One was defendant admitted it was himself in the video where he was talking about having no mercy and displaying the actual bullets that killed or the bullets we believe that killed the victim and injured the other. No one else had a weapon. There was evidence from the video that the gunshot was shot before the defendant was hit in the with a helmet because you saw the crowd dispersing before that had happened and the gun had misfired. There was no self-defense claim for 11 months until after the video was displayed and shown to the defendant. And an acquittal would have been unreasonable. If there's no further questions from the court, people will rest on the papers.
Thank you, counsel.
Thank you, Your Honor.
Okay, case number 996, People versus Kenneth Campbell.
Good morning. May it please the court. Allison McMahon on behalf of Appellant Kenneth Campbell. Mr. Campbell's sentence was improperly enhanced after an alleged Outly violation. The explicit condition imposed by the court was not to commit any crime or offense. It was not simply not be arrested. And so in Outly, the case itself distinguished these as kind of 2 different conditions.
Is that argument preserved? That argument wasn't made below, was it?
So while it wasn't fully preserved, Mr. Campbell made clear on the record he was planning to appeal it. And when he tried to make any statements about the arrest, the court told him not to speak about it. So that kind of...
Because as I recall, he was getting sentenced for that second arrest right subsequent to this.
It had happened pretty recently. There was no there was just a felony complaint filed in that case. Then there was not a lot of information on the record provided about it, whether, whose residence it was he just there, and just being present isn't committing a crime. And so I think the key is that the condition was to not commit any crime or offense. It wasn't simply not be arrested.
Okay. And with regard to Justice Montour's question about the preservation, I think he was referring to the idea that that issue needed to be preserved by a motion to withdraw the plea, and that certainly was not done here.
That is correct. I think a lot of the issue here is that the court denied him any opportunity to offer any information that would dispute the basis of what happened by telling him not to make any comments whatsoever about the new arrest. And as part of the conditions were that, you wouldn't be able to withdraw your plea. So I think that is also something to consider.
Okay. Thank you, counsel.
All right. Thank you. If there's no more questions, I'll rest.
Good morning. May it please the court, Will Zickel for the people. With respect to the preservation issue, there are two ways that such an issue can be preserved. The defendant availed himself to neither of them. And I think it's important to note what happened at the appearance itself, which was the defendant fully acquiesced to the finding that he had violated his outly warnings, whether it was a violation relating to being arrested or committing another crime. There was full acquiescence there. So there was no reason for the court to inquire any further than it did. If the defendant had asked for a hearing, there might have been another avenue that was followed, but they simply didn't in this case. And so there was no reason for the court to take it any further than it did. And with respect to the court silencing the defendant or not allowing the defendant to speak, I think this court should take note of when that occurred in this proceeding. And that is at the time the court was about to pronounce sentence. The defendant has the right to make a statement at that time. And so the court allowed the defendant to make a statement, and the defendant started talking about the new charge. And that's when the court stepped in and said, you might not want to say anything about the new charge. You could offer something else, in mitigation or in your favor with respect to the sentence I'm going to impose today. But you might want to hold off on the new charge. He was charged with a B felony and a D violent felony on the new charges. And on the date of this sentencing, he was only exposed to a Class E felony.
Okay,
If there are no questions.
thank you, counsel.
Thank you.
Case number 997, the matter of Willie Miller Jr. Okay, my computer here says we have an in-person. Sure, please. Okay, we will deem this case submitted. Okay, case number 998, matter of Lalisa Craig versus Adam Thomas. Morning, counsel. Yep. There are two folks that are coming via the internet here.
Over here, right? So.
We have two.
No, where she's been sick.
Oh, is that what the question was? I'm so sorry. Yes. You're good. You're good. I think they're both coming any second.
Or not.
Oh, here comes somebody. Morning, Mr. Tessman. Can you hear us?
Yes, I can. Can you hear me, Your Honor?
We sure can. Okay. We're waiting for one other counsel to check in.
Yes.
Your Honors, Thomas Pelch is in the meeting, but he is having trouble turning his video on.
Okay. Will he agree to appear on the telephone only, without the video? We'll agree to hear his argument that way.
Okay, well, we'll try and get him because right now he isn't able to use his voice either.
Okay, can we maybe put this off until he's able to be part of this? Okay, take another case before, and can you let me know when he's ready?
Will do, Your Honor.
Okay, we'll put this aside. Sorry for any inconvenience.
No problem.
Okay, case number 999. Greg versus Community Care Companion. Both virtual appearances. Morning, council. Can you hear us?
I can hear you. Can you hear me?
Perfect. Yep.
May it please the court?
Oh,
Jessica.
hold on. We're
I
still waiting
apologize.
for one more, Mr. Schenker.
I got excited.
Oh. Okay. Good morning, Mr. Schenker.
Yes, I'm here. A little delayed, but I'm here.
Perfect. And you can hear us and we can hear you. All right, Ms. Harris, go ahead.
Let's try this again. May it please the court? Jessica Harris for plaintiffs' appellants. Plaintiffs' appellants are 51 current and former home care workers employed by defendants, community care companions, AJ Caro and Mark Gaydon. They brought this action alleging that defendants' respondents had failed to provide them with hiring notices compliant with New York Labor Law Section 195(1), and additionally on behalf of a class of similarly situated current and former employees of defendants, that defendants had failed to pay them an additional hour at the minimum wage rate for each day in which they worked a split shift or a spread of hours that exceeded 10. The lower court dismissed plaintiff's complaint in its entirety on 4 grounds. The lower court first held that plaintiffs lacked standing to bring their hiring notice claims under Section 195(1). Second, that plaintiffs had not stated claims against the individual defendants. Third, that plaintiffs had failed to state a cause of action alleging hiring notice violations under New York Labor Law Section 195(1). And fourth, that plaintiffs had failed to state a cause of action for split shift and spread of hour violations. The court erred on each of these points. First, with respect to standing, the lower court held that plaintiffs lacked standing to bring their Section 195(1) claims on the basis of the United States Supreme Court's 2021 decision in TransUnion versus Ramirez. Neither that decision nor the 29 federal court decisions that followed it, cited by defendants in their brief, has any applicability here. TransUnion held that because the United States Constitution's Article 3 case or controversy requirement requires a plaintiff to plead a concrete injury, Congress could not statutorily create standing through legislation. But as the Court of Appeals recognized in Society of Plastics versus County of Suffolk, there is no case or controversy requirement nor any analogous requirement in the New York Constitution. And as such, the New York legislature can, without running afoul of any constitutional requirements or prohibitions, create standing through legislation. Although there is an injury in fact requirement at common law in New York, as the Court of Appeals expressly held in Harkenreiter versus Hochul, which is controlling here, courts need not and should not resort to common law principles of standing, whereas here the statute identifies the class of persons entitled to sue. Notably, defendants here do not dispute that New York labor law expressly confers standing on plaintiffs, and that should be the end of the inquiry. Defendants cite a single state court case where a Section 195(1) claim was dismissed for lack of standing on the basis of TransUnion. That's Best Work Holdings. And that decision was recently reversed by the First Department in an October 14th, 2025 decision. This court, too, should reverse the lower court's dismissal of plaintiff's 195(1) claim for lack of standing. Second, the lower court erroneously held that plaintiffs cannot bring claims against Gaydon and Caro because individual corporate officers can never be held liable as employers under New York labor law pursuant to this court's 1983 decision in Staganovich versus Dinolfo. In fact, Staganovich expressly recognized that Section 198 of the labor law creates a right of action by employees against an employer for recovery of wages, and New York labor law Section 190 defines employer as including any person employing any individual in any occupation, where to be employed under New York labor law Section 2, which applies to the entirety of the labor law, means to be suffered or permitted to work. For this reason, the First and Second Departments and numerous federal courts, including the Bay Court in the companion federal court case, have repeatedly held that individuals may be held liable as employers if they exercise sufficient control under the economic realities test over the corporation's activities such that they can be deemed to have suffered or permitted the plaintiffs to work. And indeed, defendants failed to cite a single case interpreting Staganovich in the manner in which they urge. Because
Counselor, can I ask you a question on that?
Please.
Is it your argument that if a corporate officer uses its normal role as a supervisor, that those are the types of things that could hold them personally liable, or does there have to be something more that they do, like step outside the corporate shield, for example? Like authorize some illegal activity, like you're alleging here, that it wasn't lawful for them not to pay the proper wages. Does that need to be alleged, and was it alleged here?
No, Your Honor. There is no requirement that the individual defendant have been personally involved in the activity that violates the law that was alleged to have been violated. The requirement is that the individual have been the employer as defined by the statute, meaning that they suffered or permitted the plaintiffs to perform the work. And to answer that question, the Second Circuit and federal courts, as well as New York courts, consider the economic realities test, which was set forth recently by the Second Circuit in Irizarry versus Katsimatidis, but has been used for decades. And the court looks at various factors that go to the level of control that the defendant has over the employee's terms and conditions of employment. So the court's looking at, does the individual have the authority and have they exercised the authority to hire and fire? Do they have the authority to set the wage rate and the method of pay? Do they?
Would those, counsel, would those be the kind of facts that we would develop during discovery should this case go forward?
Yes, Your Honor.
Okay.
And plaintiffs alleged in some detail the various facets of control that the individual defendants exercised over the plaintiff's terms and conditions of employment here.
At this point, we're just looking at sufficient pleading.
Yes, Your Honor.
Okay. All right.
For all those reasons, Your Honors, the lower court's ruling dismissing plaintiffs' claims against the individual defendants should be reversed. With respect to the lower court's ruling that plaintiffs had failed to state a cause of action under New York Labor Law Section 195(1), the court held that the complaint was not sufficiently specific. The CPLR does not require great specificity. Under CPLR...
Again, counsel, is this the kind of facts that would be, developed during discovery should the case be reinstated?
Yes, Your Honor. Plaintiffs have stated a claim sufficient to survive a motion to dismiss. Whether plaintiffs can ultimately prove that claim is not an issue before the court at this time. Plaintiffs have alleged have pleaded sufficient facts to put the court and parties on notice of the transactions or occurrences at issue. Here, the giving or not giving of the notice at hiring or within 10 days thereafter, and the material elements of the cause of action, which here under Section 195(1) is the plaintiff an employee? Did they receive a notice that contained all the information required by Section 195(1) at the time of hiring or within 10 business days thereafter? And plaintiffs have alleged those. At paragraphs 33 to 83, plaintiffs allege that they were employed by the defendants and the dates upon which they were hired. At paragraphs 93 and 104 to 106, they allege their belief that they did not receive notices that were compliant.
And counsel, yeah, we do have the record and we do have the complaint, so I think you could.
Understood.
Okay.
Moving, Your Honors, to the last ground on which the court dismissed plaintiff's claim, which is the failure to state a claim for split shift or spread of hours. Again, the lower court held that the plaintiffs were required to, but did not allege the specific days on which they worked 10 or more hours and were paid at or below minimum wage. Again, that level of specificity is simply not required, and the complaint does set forth adequate allegations to satisfy the liberal pleading standards under the CPLR. For all of these reasons, the lower court's dismissal of plaintiff's claims should be reversed on all grounds. Thank you, Your Honors.
Thank you, counsel. Counsel?
Good morning, Your Honors. May it please the court. My name is Brian Schenker on behalf of defendant respondents, Community Care Companions, Inc., Alexander Caro and Mark Gady. This case involves 51 plaintiffs who are current and former health aides who work for community care. These 51 individuals must make a showing as to why their individual claims survive, and they have not come close to doing so, as the lower court found. Plaintiffs fail to assert individual factual allegations as to any cause of action. The two causes of action, as counsel stated, are with respect to the wage notices at hire and an alleged failure to pay spread of hours or split shift premiums.
Okay, so I'm imagining that you disagree with counsel, that your opposing counsel, that these are the kinds of details that would be developed during discovery should this case be reinstated.
Yeah, absolutely, Your Honor. They have not even asserted facts on behalf of their own plaintiffs to get them across the threshold. And we'll start with the 195 wage notice claim. But to fully understand that, Your Honor, this is a splinter action from a pending federal case pending in the Western District of New York, brought by the same counsel and several other home health aides. In that case, following extensive briefing, the court refused to certify a class for the wage notice claim under 195, and in fact, sua sponte dismissed the named plaintiff's wage notice claims for lack of standing. And in doing so, the court also stated it doubted that the technical nits in the wage notices, the same ones they're alleging in this case, the federal court doubted that those were even actionable under 195.1. So now plaintiffs have, filed this lawsuit in an attempt to work around their dismissal in the federal court. And once again, they do not have standing. Why is standing still requires injury in fact? Indeed.
Does it? Haven't there been cases that say that that's not so?
Your Honor, I think that it's been very clear that for statutory violations that you don't just look to the statute itself, right, to see whether you're in the zone of interest, but the plaintiff must also show that they were hurt, show that they suffered a harm. That's more than just the statutory, violation. And so even in Best Work, VMA, the First Department case that plaintiff's counsel referenced, in the First Department decision from October 2005, that court relied on Ramirez v. TransUnion v. Ramirez. That court relied on the Supreme Court case that said that you need to establish an injury in fact. And in that case, they did. The plaintiff alleged they did not receive a wage notice in their native Chinese language, and therefore they didn't know the name of their employer, they didn't know their rate of pay. Here, in this case, the complaint contains no allegations as to any harm. Plaintiff's theory is simply that they can say—
Well, counsel, if they fail to receive the notices as under 195, all right, I think that the complaint alleges that, and we have to accept that as being valid and true, correct?
Your Honor, respectfully, the complaint does not state that they did not receive them. The complaint only alleges things about the wage notices in the federal action. They make allegations about the 75 wage notices that were considered about by the federal court. They don't make any allegations regarding the 51 plaintiffs in this case about—
Well, and again, if the complaint's alleging that the fact that 195 was violated, in discovery now, I'm sure not every 51 of these employees didn't receive the notices on the same date, or if they received them all. I mean, they're entitled to bring that out on discovery. I mean, it says it'll be simply brought out, in whether or not plaintiff number one received it on a certain date versus number two versus, the dates can be elaborated on under discovery.
So, Your Honor, it's not just the dates. They don't say whether or not they received one, right? We don't know if that's their claim that they didn't receive one, or are they claiming they received one, but it's lacking certain information. that's required by the statute. They don't say any of this. So we have no idea what these plaintiffs are saying. And as the lower court stated, the only factual allegations asserted on this are the percentages of alleged wage notice compliance in the federal action. So if we permit this case to go forward, that means that any plaintiff can just allege things about other actions, about other individuals, and nothing about themselves, and get into court that way. And so that is not proper here. They have not alleged a single deficiency in their own wage notices. They have not specified any facts regarding whether or not they received one. They don't even say that, whether or not they received one that lacks information. And so on that basis, Your Honor, they haven't established both standing and they haven't established an actual claim, right? That there was a violation of the law.
Okay.
And so, Your Honor, then I'd like to move along to the plaintiff's spread of hours and split shift claim. Here, the employer is required to pay minimum wage workers, only minimum wage workers, an additional 1 hour at the minimum wage rate if they trigger the split shift or spread of hours. And so what does that require? The material elements of the claim are that they worked a work day exceeding 10 hours, or that a split shift was worked, that their rate of pay was at the minimum wage, and whether their rate of pay for that day plus the premium that they might be owed was sufficient, or whether additional compensation is needed. These plaintiffs do not say anything about this. Plaintiffs fail to identify any shift. And again, there are 51 of them. And Your Honors, there are 2 paragraphs in the complaint about this cause of action. This is not a class action. These 51 plaintiffs need to each establish their entitlement to establish their claims. They can't group them together as if this were a class action. And there are no facts beyond the recitation of the law with respect to this claim. Plaintiffs do not allege they actually triggered the spread of hours provision. They simply allege that, quote, defendants employed plaintiffs to work split shifts and spread of hours, and therefore were owed spread of hours pay. But
Well, counsel, let me ask you this, okay? I mean, I could ask you the same question that I've been asking. Wouldn't this be the kind of thing that would be discovered, developed during discovery? But my second part of that question, isn't your corporation the holder of the information of what hours these people worked and whether they received this information or not?
Your Honor, each of these plaintiffs received weekly wage statements that provided that information to them, and they have that. And the way we know that is they didn't assert a claim for failure to provide wage notices under Section 195(3). So it is completely incorrect that the plaintiffs do not have this. They have it, as defendant was required to provide.
Well, that really wasn't my question, whether they had it. My question asked whether you have it. And I think that you probably have that information within your corporate records as well. Whether that matters or not, it is something that I believe that if the claim was reinstated, if we don't agree with you on your first argument, then this is the kind of information that could be developed during discovery, and you're not without the information on your own.
Your Honor, I suppose my response to that is, I suppose in every case, the allegations can be expanded and discovered. But the question is, have these plaintiffs done anything more than basically say, we worked for this company? And they haven't. They've said they worked for this company, and they haven't stated any allegation that comes close to triggering any violation of the labor law. And so if we permit this to go to discovery, then it's saying any employee can just say, hey, I work for the company, and now I get discovery and I have a lawsuit. Because
But they said more than that, though. I mean, and isn't your argument that they just allege the bare statutory language, which does allege the violation, but your argument's really they didn't allege the specific facts such as pay rates, dates, etc. Right? Isn't that really your argument, or no?
Yes, Your Honor, that there are 51 plaintiffs that have not stated they worked a shift of 10 hours or more and weren't paid enough for that shift. We don't have an allegation like that in the complaint. Likewise, with the failure to provide a wage notice claim, we do not have an allegation in the complaint that says plaintiff 21, whoever that is, that maybe they didn't receive a wage notice at all, or maybe they received a wage notice, but it was missing their rate of pay. We do not have any of those allegations in this. And so again, essentially, they are just saying, we work for the company, here's the law, let us go forward and get discovery.
And I promise we will carefully scrutinize the plaintiff's complaint to analyze whether or not those kind of allegations can be read within those lines.
Thank you, Your Honor.
Okay.
And then I suppose I will move finally to the lower court's proper dismissal of the claims against the individual defendants. And again, to the extent the court upholds the lower court's decision, there's no need to reach this issue. But to the extent it does, the court correctly determined that Caro and Gadian were not responsible for plaintiffs' wages. Plaintiffs are suing both Gadian and Caro as co-owners, as CEOs and members of the board, which is stated in their complaint. However, even after having a shot at amending the complaint, the plaintiffs have asserted only conclusory allegations regarding general corporate matters. There are not allegations that the individuals defendants did anything related to the plaintiff's employment. And therefore, as set forth in Staganovich, the court should not imply liability in this scenario. Because, and again, they are not alleging these owners were involved with the plaintiff's employment. They are simply trying to hold them liable as high-level officers of the company, which Staganovich, which applies in this department, says cannot be done. And again, on this point, plaintiffs only cite non-binding federal district court decisions and decisions from other appellate departments, and none of which show why the lower court's ruling should be disturbed on this issue.
Hey, counsel. Any other questions? No, I think we have your argument. Thank you.
Thank you, Your Honors.
All right. All right, I'm going to recall case number 998. Getting your steps in today. All right.
It's it.
Okay, Mr. Pellich is on the line. We're waiting for Mr. Tessie.
Your Honor,
Yes,
Mr. Tessieman is in.
there
Okay,
he
there he
is.
is.
Perfect. All right. All right, I think we're ready on this one now. Okay, Mr. Pellich, I guess you have the floor.
Okay, good morning. May it please the court. And my apologies for my prior tech issues.
Not a
My
problem.
client, the appellant, Lisa Craig, is the maternal grandmother of the two subject twins who are now 10 years old. I know that there's been a number of recent developments related to the parties in this case.
Wait,
So
recent
I'm gonna-
meaning since this appeal was filed? There's been
Correct.
continuing.
I'll defer to the AFC on that. A number of documents have been submitted to the court, but I believe that Ms. Ciccione can speak to that during her time. So I'll just kind of focus on the facts of the issue at the lower court.
Well, can you tell us what your client's done in the meantime too, instead of deferring that, because she's the one
Sure.
that brought the
Sure.
action.
Would you like me to do that now or
Well,
on the back end?
yeah, I'm asking you now. Could
Sure. So at the moment, my client has custody of the subject children on consent between her and Mr. Thomas. I've seen the.
As their consent, meaning has there been a subsequent order? Signed?
There was an order signed, I believe, late last week. But I believe that we should still be here on the appeal as opposed to it potentially being moot, because the reading of the new order, there are a number of clauses that could potentially bring the parties back before the lower court. Chiefly, if Mr. Thomas is released from his incarceration.
Okay, so he's been reincarcerated?
That is correct. He's been charged and I believe indicted on a number of felonies. And I believe he's currently remanded in Wayne County, is my understanding.
Okay, go ahead and make your argument, and but this is important to the court, that we know what the subsequent orders have been.
Sure. So the primary issue with the lower court after a custody determination where the children's mother tragically passed, following that, my client took custody of the children, and then there was a custody trial between her and Mr. Thomas in Wayne County. Her petition was ultimately dismissed for a lack of standing for not having extraordinary circumstances. And
Wasn't the father incarcerated beforehand at one time?
he wasn't at the time of the trial. He was previously over a time from 2018 to sometime in 22. To be completely honest with you, rereading the record and the testimony, some of the timelines are a little unclear. I'm still somewhat uncertain, like when he actually went to prison, when he was released. But I think among the parties, it's indisputed that he was incarcerated and the children lived with my client for a minimum of a period of 2 years and 10 months.
Is that a factor that should be considered as far as extraordinary circumstances?
As far as under domestic relations law, section 72 A and B, I believe that would qualify as an extended disruption of custody. And it would then, fall upon this court respectively to look at the totality of the circumstances and whether or not the relinquishment of custody was voluntary or, just if extraordinary circumstances exist otherwise. In this case, Mr. Thomas.
Wasn't it a very brief period of relinquishment?
Well, I think that it can be argued that the custodialship was relinquished during the course of incarceration. The children never visited their father. He, I believe, infrequently called them. He never sent any cards, never acknowledged holidays or birthdays.
I mean, afterwards. So your client had custody of his children for a long period of time. Father then had custody of them for a short period of time. By my calculations, maybe a month. Okay, and before things changed again. Okay, is that a reasonable review of the record?
Yeah, I think that's reasonable. And just to clarify, my client never had formal custody. They were always within the custody of the biological mother, but they did live with my client during that period. And as you correctly noted, there was a bit of back and forth following Mr. Thomas's release. But regardless, I believe that the requirement by the statute was met by the period of about 3 years where the children lived with my client.
You started your argument by saying that, arguing against the mootness, but because you said there's some specific issues that you think this court needs to address. What are those specific issues? Could you drill down on those? And
yeah,
you do have a subsequent order now.
Yep, I think hypothetically, if Mr. Thomas was to get released, his charges were to be dropped, which you never know could happen in a criminal case. He could go back to court. He could under the order he would have standing as a change of circumstances upon his release. And
right, but why wouldn't that just be what he would do then? The changes of what? Why would we?
Because at that point, the same judge in the court would be able to use its prior decision to deny my client standing. So if this court is able to rule upon whether or not she is standing, that would not be able to be used against her in that same court in the future.
Right, I understand. Okay, anything else you'd like to?
I think we covered all the points, and I would just respectfully request that this court look at the totality of the circumstances of this case, where we would submit that the extraordinary circumstances are certainly met. Thank you.
Thank you. Mr. Tessington?
Thank you, Your Honors. May it please the court. I believe that Judge Williams got this right, that there was not sufficient evidence to show the extraordinary change in circumstances. Here, the father had been incarcerated, yes, but after his release for incarceration, the mother asked the father to take the children, and he had them for an entire school year, not 1 month, at least 9 months, if not longer. The fact is that the grandmother never had custody of these children. The children were either in the care of their mother or their father, and the grandmother
The children
resided
lived with the
them.
grandmother consistently, correct?
No, that's not correct. The
There were a
grandmother
few months
moved.
when the mother moved out of the grandmother's house that the children went with the mother, but then they went back to the grandmother.
No, the mother and the children lived at various times with the grandmother, but in the years prior to the bringing of this action, the grandmother had moved out of the house with the mother and the children. It was the grandmother who moved, and it was after that time, after she moved, that the mother, according to the testimony, asked the father to take the children, which he did for the entire school year, 2022 to 23, I believe. And also considering whether or not whether they were over the summer. Now, they had relied a lot on this phrase, living together. According to statistics that I saw, about 10% or more of all Americans live in a multi-generational household. That in and of itself, I would say, does not provide extraordinary circumstances. The grandmother never really testified as to what kind of custodial actions she took with the children, how she was a de facto custodian, and in the fact that for a substantial period of time before the father even took custody prior to this action, the grandmother did not reside with them. Living together.
What about the father's failure to communicate with the children for 4 months, right around the time the petition was filed? What do you
No,
say?
that was, I don't read that in the transcript that for a few months.
It is in the record, but.
The father's communication with the children also, while he was incarcerated, we also have to bear in mind that this was also during the period of the pandemic, when we were limiting contact between people. But the very fact of his incarceration is not a voluntary surrender. This court's already ruled on that. The fact of the matter is that the grandmother failed to show that the father's relinquishment of any custodial rights was voluntary. His incarceration was involuntary.
Whoa. His incarceration was involuntary? I mean, haven't courts deemed times where an individual was incarcerated that the acts that precipitated the incarceration were voluntary? So obviously his placement as being incarcerated in prison was due to a voluntary act on his behalf.
I'm not sure that it applies in all cases, Your Honor. If a person may be serving time for involuntary manslaughter, by definition, the act that placed him there was involuntary.
I don't think we have that situation here, though.
No, but I believe that in Lisa F. versus Thomas E., the court clearly indicated that in a period of incarceration can be involuntary.
Counselor, in your opinion, what is the effect of the current order then on this?
Well, the ship may have righted itself, but my point basically is not that Mr. Thomas might be the most wonderful father in the world, but that there wasn't sufficient evidence before Judge Williams to show the extraordinary circumstances, and his ruling is correct based upon that fact.
Can you tell us about the charges that led to him, or what his conviction was for, that he's reincarcerated?
His incarceration now is on new charges. That
And I'm
just
asking about
occurred,
that.
just occurred within the past few months.
Okay, so there hasn't been a new conviction.
No, there has not been a new conviction that I'm aware of.
Okay, a new incarceration and
And I believe that this order is just a temporary order. And I agree with Mr. Appellate that this case is not moot because of that, of the current situation.
okay.
And therefore, it does merit the consideration of this court. I was concerned because if there had been a final order, then I would, of new custody, I would agree that that this matter was moot.
Okay. Well, thank you, Mr. Tessin.
Thank you, Your Honors. Thank you for your consideration.
Yeah.
May it please the court. Kelly Chacon, attorney for the children, Anila and Malaya Thomas, who will be 11 in February. I have a lot to say. First of all, I sent to the court a notice of change of circumstances, and I apologize that you did not see that. There was some discussion about whether or not that was appropriate under the circumstances here, because I do not feel that it renders the appeal moot. However, I did not want the court to be surprised, and it appears that there's quite a bit of surprise about what's going on. So I can fill the court in on that, and I would be really happy to. So you may recall from my brief that during the time that the entire time this appeal has been pending, I tried to reach out to Mr. Thomas, who had custody of the children, to meet with my clients. He never responded to me. I tried several different methods, no answer.
Meaning his children.
His children, yes, I'm sorry, my clients. There was a change of custody, temporary. The current order is not a temporary order. It has been entered. They did consent to it. The charges are, again, drug charges, gun charges, endangering the welfare of a child, including my two clients, who were the ones who actually turned him in. So I did meet with my clients after I found out that they were with grandma, and grandma got back to me. I had a meeting with them, and they were very clear that I could tell the court all of this. Of course, they are fearful, and they are fearful of repercussions, but they want you to know that father came into their bedroom one night, or one of the girls' bedroom. I guess they have separate bedrooms in their new home, and put a bag in her closet. The little girl was curious, woke up and, heard her father in her bedroom in the middle of the night, got curious after he left, went in and found a bag full of guns, drugs, and money. She took pictures. She texted it to her grandmother, please get us out of here. One of the girls, the other child,
How old was this child?
10 years old. These children were being used by dad, according to them, as assistants in his drug business. They were asked to count money. They were asked to weigh things. They knew what a scale was. They knew what a money counter was. One of them, like I said, Anila, ended up in the hospital because dad was cooking the drugs on the stove, and the fumes made her sick. The terror that these children were living in the entire time they were with dad during this order, I can't even imagine. So, yes, I'm passionate about this. Representing children is the reason I became a lawyer, so I apologize, Your Honors. This is horrible.
How long is this temporary order? They're not temporary. The current permanent order.
It just was entered like last week, but I think the children have been with grandma since, I think, September. I think he was arrested in September.
So, Counselor, what would you like us to do?
I will tell you what I would like. I would like an order because, nobody caught section 72 subparen 1 of the domestic relations law, not any of the trial lawyers, not the judge at trial, that gives the grandmother, according to the practice commentaries, I wrote that down, absolute right to petition the court when one or both of the parents have died. Now, you could interpret that as only for visitation. I will note that in reviewing the statute for today's appearance, I see that the New York State Legislature, both houses have bills that intend to expand those rights now to great grandparents. So the trend now is to, make sure that the family of the deceased parent still has standing to get at least visitation. And, my second point in my brief was that, the court said, okay, so it's going to be visitation as the parties may agree. Well, grandmother had these children for a year while the trial was pending. Dad never saw them, never called them, never sent them a gift. He was not incarcerated during that time. So he was never going to communicate with grandmother. And in fact, after the order was entered, he didn't. So these children didn't even see their father for over a year until, custody was ordered. So what I would like is an order reversing the prior order to make it consistent with statute. I don't think that
Basically saying that grandmother has.
had standing. Yeah, I don't want this to be used as a precedent for any other grandmother in the situation where she's lost her daughter, her grandchildren are in the custody of this criminal, and she can't come back and try to get custody of these children. It's an aberration. It has to be.
We'll look at it very carefully.
Thank you.
Thank you, counsel. Okay, case number 1000, McKeon versus Blair et al.
Good morning. May it please the court, Justin White, appearing on behalf of the plaintiff appellants. We're seeking to overturn the lower court's summary judgment decision in favor of Mr. Joyce's clients. We think, first of all, that the court, quote, got it wrong when it concluded that the Blairs had permission to pave over the easement area that they did. We believe that the easement agreement was very specific about what purpose it had a vote for, which was maintenance. It did not have a vote for changing the terms of the easement. And under the Lewis versus Young authority that I cited in the brief, when you modify an easement, you do so with everybody's consent and you do it in writing. And Mr. and Mrs. Blair snuck one under radar by having only 3 of the 4 property owners sign the easement agreement, or whatever the heck it was, permission letter. Number 1, and number 2, the serving and tenement owner was not a party to the easement permission letter. So that's the beginning of the IAS court's error. Secondly, with respect to the easement somehow allowed for this intrusion of the asphalt and the resulting flooding, it did not provide for any such thing. And moreover, an interpretation of the easement requires that one look at the serving and tenement owner's rights as opposed to the dominant tenement owner's rights under several cases that are cited in the brief.
About the fact that the court ruled that this was time barred.
I was just going to get to that, Justice Montoya.
Sorry, I jumped the gun.
No. Thanks for the intro. Actually, the cases that we cited in our brief, specifically 509 6th Avenue Corp., which is a Court of Appeals case, and the Kramer versus Kleiber case, which is this court's decision, provides that when there is an encroachment that continues, it is a continuing trespass. And both Kleiber and 6th Avenue involved pipes that were subterranean. The pipes existed beyond the dominant tenement owner's property line and moved into the serving tenement owner's property. So as long as those pipes remained there, that was considered a trespass. And trespass that doesn't stop, that continues, allows for a continuous wrong doctrine to be applied for a period of at least 10 years.
Did your clients already have drainage issues when they purchased the property? They're aware of those?
Which, Your Honor, were addressed by the drainage system that was in place that Mr. and Mrs. Blair asphalted over. They wiped it out. So,
But I think even before the extension or the addition of by the Blairs of their driveway, I think there were already issues concerning drainage that your client had. And they were aware of it.
well, the drainage issues, we're not contending that those drainage issues never disappeared. I mean, they always continued, but by virtue of what Blair's did, they were exacerbated. Their driveway constituted a chute down which water ran, and added to the fact that it wiped out the drainage system, it was a double whammy to the McKeons. And the simple solution is to put a drainage system in beyond, above, or below where the Blairs put their asphalt extension. And the court wasn't intrigued by that notion, and we think it ought to have been. I have no further comments. Thank you.
Thank you, Mr. Wong.
Good morning, Paul Joyce for Woodmere and the Blairs. Judge Montour, there were drainage issues. These are properties that sit at the bottom of a hill, including a neighboring hill to the west that isn't in the record, but recently removed their trees, so there's water flowing down. The Blairs installed significant drainage in their property. I think the key here is that the easement is for a private road. It allows access to all four properties.
How about what Mr. White was saying, that with the easements for maintenance and you extended into this easement?
The language of the easement is for a private road. Also says maintenance needs to be performed, but it's for a private road. And if you look at the entire survey, it says private road over both the Lapadas, the McKeons, the Blairs, and formerly Miss Fuchs.
And then this extension, the work that the Blairs put in, did not extend over the private road.
It did go into the private road.
Well, so it didn't extend over the boundaries of the existing private road. Is that correct?
I don't understand your
If
question.
if the road was 10 feet wide and their extension that they made or adjustment that they made so they could pull in, still was at 10 foot, was still 10 foot.
Yes.
Okay.
So it
Sorry,
just,
I didn't phrase my question.
it just went from the private road went not quite to the western end of the property. And they just paved a part to go north to get to the garage. And there is actually a drain in the,
A big hole.
yeah, well, it's a covered drain. So with other sorts of drainage. So getting to the statute of limitations, it is a single time. This was built in 2013. The McKeons bought their property in 2014. They knew going in, we have this road, we can see it. They knew that they testified there were drainage issues. They could solve the problem by adding drainage to their own property. They haven't. So I think the trial court's orders should be affirmed. And I appreciate your time if you don't have any other questions.
Thank you very much.
Thank you.
Okay, case number 1001, Cuba Lake Committee versus the Town of Cuba.
Good morning, Your Honors. James DeMarco, representing the state.
Good morning, Mr. DeMarco.
I'm very excited, Mr. DeMarco, to be here.
Can't wait to get to the vote.
Okay, the floor
It's
is
nice to be here. That's what I can say.
yours.
Thank you, Judge. As a court aware of the meaning of the case, it is our position that the Supreme Court erred when it declared the entire role void, null and void. At the outset of this, as the court's well aware, it's presumed that the taxing authorities is usually correct in its decision. And that's something that has to be rebutted at that time. That's
Mr.
what
DeMarco, the appraiser that was used was reputable?
Yes, Your Honor. I'll be getting into that in a
They used a
bit.
market value analysis, right?
Yes, Your Honor.
They apparently inspected every parcel.
They did, Your Honor.
They took photos.
I beg your pardon. I apologize, Judge.
I'm just gonna go through a litany here, so
Sure.
be patient with me. I know you're excited.
am.
Very excited.
Yeah.
And you can repeat something I say. Apparently, they reviewed over 300 responses to inventory questions.
That's correct, Your Honor.
And they analyzed 3 years of pertinent individual sales.
They did.
And they considered the ownership differential related to the petitioner's position here regarding this leasehold.
They did, Your Honor, and even went into the methodology in which they did look at the difference in the lake houses as opposed to others.
And as you said, initially, that is presumably valid.
It is,
Right?
yes.
And it's responsibility of the individuals here, the appellants or the petitioners, to rebut that.
It is, Judge. That is our position. Yes.
Go ahead.
Thank you. Judge, in regard to rebutting the position, the Adams case was cited in regard to really. Adams is distinctly different from this case. That case had to do with selective type of situation, actually selective appraising. In that case, the court actually appointed a referee with specialized information to rely upon what had happened. In this case, we have an ordinary citizen who took it upon himself to state that this is what's wrong, not the methodology, not the methodology.
What were his qualifications?
None. He is, no, I shouldn't say that, Judge. They didn't set forth any specific qualifications that he possessed, no specific training that he possessed, no courses that he took that would elevate him to the level. And it's a good point, Judge, because
They take photos. They look at all the property.
I can't say that he did. What he did say, Judge, is that he applied simple math to land tables. The appraiser, and with the assistance of the firm that was hired, they provided land tables, although there's some disagreement as to what that was, or if in fact it was, and disagreement in regard to the inspection. But with that, Judge, it comes down to what they claim is simple math. I applied simple math to the land tables, and I came up with an amount that we believe is incorrect. Again, not the methodology.
Well, let's be very specific. Isn't there argument basically that the lease of state land versus that wasn't properly analyzed, that they shouldn't even be paying tax? That's one of their arguments, right?
It was, Your Honor. Yes.
On your, you only have to prove there's a rational basis for the assessment.
That's where I was going, Judge. And the reason for that is that anybody then could do it without any type of special training whatsoever and just object to whatever is put forth. That's where the presumption is that the taxing authority is correct, and that has to be rebutted.
Right, so their argument could be valid, but it's not enough to win.
Good point, Judge. The reason is in my briefs, I've set forth the decision in Hallerstein, where in Hallerstein, it's even a worse case than what we have here, as alleged, of course, that they found in that case that it was unconstitutional what was done. But in that case, Judge, they didn't throw out the entire roll because of the fiscal chaos that it would cause, not only to the town, not only to the village, not only to the school district, but we're also talking about the county.
And I wanted to ask about that fiscal chaos, because since they've thrown out the roll, what's been happening in Cuba over the last few years?
Well, Judge, that was just really done, and there is some issues that are going on to try and rectify the boat.
But no subsequent roll has been filed?
No.
You've been living by the old rules?
They have been, Judge.
Okay, all right. That's...
In regard to that, though, they've been band-aiding certain things, doing what they need to do in order to comply. In regard to what has happened and what the lower court has done, again, Judge, it's our position that the attack isn't on the methodology. The attack is how they did it. So in order to succeed in the 78, they have to show that the methodology in and of itself was arbitrary, capricious, illegal, unconstitutional, selective. In this case, that's not true, because going back to your question, Judge, when the whole project was done, they took into consideration all parcels, the uniqueness of each and every parcel. Some parcels that are on the lake that didn't own the property and were leased, those got a zero land value. So we took into consideration that particular issue. The uniqueness of where a property is, the desirability of it, the size of it, where it is, all those are taken into consideration for the methodology, not just one particular issue. Also, Your Honor, you don't need to visit every single property. You don't need to do land tables in order to arrive at.
But they did that.
But they did. They went over and above. They held public meetings. They fielded questions from them. They told everybody at the outset.
Let me interrupt you, but they might have done one thing that wasn't correct. And that would have been the constituting their assessment review board.
Your Honor, I was going to end with that. In and of itself, the failure to take the oath of office under Public Officers Law 15, that's not fatal. As long as they weren't being actively removed or they were charged with a felony or something that would make their appointment ineffective, the mere fact that they hadn't taken the oath of office in and of itself is not enough. Courts have held that the oath of office being taken after the act in and of itself is not enough, unless there is some other extenuating circumstance.
Isn't what we really need to pay attention to then, Mr. DeMarco, whether or not that error was enough to invalidate a judgment or the assessment rule?
Judge, it's something that, yes, of course, the court should look at. However, that board in and of itself is not controlling of the total assessment process. So even if the court were to find that in that case that the board failed to take the oath of office and at the time that this took place is not enough to invalidate the whole role, Your Honor. And Public Officers Law allows that to happen. In fact, I think they envisioned that administrative mistakes could be made in where the oath of office is taken after the fact and found that it did not invalidate. The more important part, Judge, is that of the three that were there, two of them had already been on bar, had been appointed, have great history, have taken training, really knowledgeable people. And the other one, and one was actually voted the assessor. So the training, the knowledge, and the participation in these types of actions are possessed by each of these individuals. The third was a town justice who himself was also privy to land types of disputes as he ruled over those. So that in and of itself, Judge, I don't believe is fatal. But if the court were to believe that, I don't think it's enough for the court to invalidate the entire role.
Thank you.
In regard, Judge, to the methodology that was, well, I'm just going to end up repeating myself, so I'll save that. For the reasons, Judge, we suggest that the lower court should be overturned, dismissed, or in the alternative that it be submitted and remanded for proper issues of trial, as there was some information that was submitted that were hearsay, that were affidavits of people that were hearsay, not subject to cross-examination, not the best evidence. And thank you, Your Honors, for your time.
Thank you, counsel. It's still morning.
I was going to say, because I don't want to say good afternoon. Good morning, Your Honors. May it please the court, counsel. My name is Nora Murphy, and I represent the respondents in this appeal. I'd like to take what counsel just said to the court and examine that if we can. Counsel repeatedly said it wasn't the problem. They're having a problem with the methodology. They're not having a problem with the methodology. They're having a problem with the way we did it. Well, if the way they did the reassessment is not the same as their methodology in conducting the reassessment isn't the same thing, I don't know how it could be more clear. The lower court properly held that the certification of this 2023 assessment roll was arbitrary. It was based on numerous egregious errors, inherent inconsistency in the roll. The court identified two substantial errors and went into detail in their decision, but the court ended, Judge Parker stated, there are so many errors that the only option is to declare it null and void. And Justice Bannister, you asked what has happened in the last couple of years, and there has been no chaos. The chaos that would result from declaring something null and void should be avoided at all costs. There has been no chaos. And in fact, the 2022 roll was reinstated by the town in July of 2025, which I would submit is an admission of the errors that have been perpetrated for 2 years by the 2023.
Let's talk about that a little bit. You said it's been reinstated. How so? Is it been reinstated as a temporary measure? Or has it been revoted as this is the assessment roll, or what's the situation?
Yes, contained in our brief, we have a copy or the language of the press release where the town notified everyone that they were rolling back to the 2022 assessment. They didn't state whether it was temporary or not. While negotiations may be ongoing between the parties, they felt that that was what they needed to do in the meantime. So 2020 for taxes 2025 were based on the 2023 roll that was declared null and void. There is a separate litigation regarding the second year.
Was there a 24 assessment done?
The 2024 assessment used the 2023 roll. They just duplicated, they used it again. After the court had already declared it to be null and void, that July, they certified the exact same assessment roll and used it again. So there was another Article 78 proceeding commenced based on the second usage of the 2023 roll.
So what's going on with that one?
Well, that was decided by the judge and that it was declared null and void again.
Judge?
Yes, and that order was actually on consent by all parties.
It's the same individual, Mr. Keeley?
Well, not just Mr. Keeley, there are multiple plaintiffs here, so it's a whole class of.
That's not in front of us.
It will be, but it hasn't been perfected yet. There has been a notice of appeal, but, and that's why the parties have tried to talk to resolve this, because it's just going to keep happening. And potentially, I can't read the mind of the town. That's why they reinstated the 2022 rule to stop this.
But this might be dangerous, but I assume that the board of review issue is not part of that case, though. They would have resolved that.
It is not that those errors, the fatal errors to the constitution of the bar were corrected. You're right.
What's your client's real remedy on a board of review not properly constituted? Isn't there like a time limit? They're supposed to have 30 days to go to Supreme Court and file their Article 7 proceeding, and isn't that the real remedy, not anything else?
No, the Public Officers Law 30H, which we argued in our papers, if a elected or appointed officer fails or neglects to execute and file their oath of office, that deems the office vacant until they do that. Now, they sat on grievance day in May and did not file their oaths of office until June. And in fact, one member was not even appointed until June, and they tried to make that appointment retroactive.
Well, I understand that, but all that does is declare the board. What is that? How does that affect their ability to grieve their assessment? Isn't their only remedy to go to Supreme Court on an Article 7?
No, because the fact that the bar was constituted improperly is a town-wide problem. It's not just a problem that affects one property owner. If the bar was acted ultra vires without legal authority, that is a town-wide issue.
But the bar would not change the role. The bar would do it individually by parcel based on a grievance.
Correct, but that's why it's a separate argument. We are saying that the assessment itself, the 2023 roll, has egregious errors that are fatal. And then we also argue that the bar was not constituted correctly, which.
Right. My question to you is what remedy, isn't it too late for the remedy on that?
I believe that the remedy that Judge Parker fashioned in effect says that it goes back to 2022, which people throughout the town had an ability to grieve their taxes back in 2022. So reinstating the 2022 roll means that the people who grieved in 2022, any person who had the right to grieve in 2022 would have still had that ability. But RPTL
Did they do
527.
that in 2022 on that roll? If I had an objection on 2022 and I went before the Board of Assessment Review, I would have already done that. It would have no effect on my ability to go against 2023.
Exactly, but if 2023, if the bar is not constituted properly, the town had the ability under 527 of RPTL to just notify the county, we don't have our bar in place correctly. And that statute gives the town a remedy. It says you can just call on these county officials to sit as your bar.
I don't see how that invalidates the 23 assessment, though. I mean, you're saying the 2023 assessment had some egregious errors. I mean, it seems like it's very conclusionary in that regard, because as I questioned Mr. DeMarco, it seemed as though the appraiser that was utilized did their job, went over and above as far as their job was concerned, did the market analysis, and it was your burden and the petitioner's burden to then overcome that presumption. And whether or not, if the appraiser used in their decision was a rational methodology, then the court should have approved.
And I understand, Judge Montour, that is the correct standard. And it's very easy for the appellant to stand up or in the answer below to say, yes, we considered all of these elements. But the reality is the role that was produced, and they say we considered all of the elements. The bottom line is that the role that was produced does not demonstrate that they considered all of the necessary elements or they applied them in the correct manner. And in fact, when we talk about, isn't this just an individual problem? Or as you just said, maybe they did it the wrong way. And counsel pointed out that, and I think Justice Greenwood, you asked him whether this was just an opinion or what qualifications did Mr. Keeley have. But I would submit to you that it's not an opinion whether or not 2 + 2 = 4. It's a fact that 2 + 2 = 4. And there is case law that says that the jurors do not need expert testimony in order to do math equations. And so the whole issue regarding the land rate tables, they did create land rate tables. And then the law says you apply the land rate tables to the mill rate that's been established by the assessment. And all Mr. Keeley did is said, okay, I did that math according to your land rate tables. And then I put those next to your assessment, and there's a $1.8 million over assessment to 791 property owners. And 1,290 were given over a $500,000 reduction. And all of this is in here. So I would push back strongly against that idea that Mr. Keeley needed some expert, that he needed to be someone who was qualified to do assessments. He wasn't doing assessments. He's saying, I've done the math and look, you're wrong. And on top of that, the assessor who had a conversation with Mr. Keeley admitted that there were errors and that the assessment was wrong. We can call that hearsay, but anybody who's been in a courtroom will tell you that it's an exception to the hearsay rule. That was a statement by a party opponent. It was an admission, and Mr. Keeley put that down in an affidavit, and that would absolutely be admissible evidence at trial. And so the fact that they want to discount that and say that was simply hearsay is a superficial look at it and doesn't exactly tell us what's true. But the land rate tables, there is no question. And in terms of the bar, which we started out talking about, the judge never quite got to that. He said it was moot because they were acting without legal authority. But if he had gone further, what we would have seen that of the 249 grievances that were filed and heard by this illegally constituted bar in neighborhood 50, which is where the petitioner respondents here land, 88% of those were denied. So let's call it 12% were accepted. In the other 3 neighborhoods combined, 92% of them were granted. So in neighborhood 50, 12% were granted, and in all the other neighborhoods, 92%. And the reason for the denials was insufficient proof. And again, Mr. Keeley doesn't need any expertise. He said, I've looked at all these packets. I looked at the packets and the people in neighborhood 50 had full packets. They had comparables, they had descriptions, they had valuations. And some of the packets in the other neighborhoods that were granted and given a reduction, some of them weren't even signed. Some of them simply had like a Zillow kind of an attachment to it of one page. So even if and we would strongly disagree that the bar was without legal authority, even if we get past that, what the bar did is so obviously arbitrary that it renders all of their actions. And I would argue that they do affect the role because they have the ability to change the role. And they obviously did that to the detriment of Section 50. I think that unless the court has additional questions, I just think that Article 7 proceedings were meant to address the individual issues. This is a town-wide issue. If we looked at the land rate tables, 90% of the parcels, 2,277 parcels, 90% of them had the wrong land values. Just by simple math, just by taking the mill rate and the land rate tables that they created. And this,
I promise we'll take a very good look at that.
thank you. But just in final, what I would say is that taxation in this country has been an issue of supreme importance since, 1774. It has to be fair, it has to be just, it has to be equitable. Equity and uniformity are the goal. Otherwise, one taxpayer escapes payment while a fellow taxpayer carries that burden. And that has happened here to a degree that is so extreme that it did warrant that the role be declared null and void. Thank you.
Thank you.
Thank you, Your Honor.
Case number 1002, matter of the Tower Foundation, John Blair. Good morning, counselors.
Good morning. May it please the court, I'm Richard Sullivan. I represent John Blair, the appellant in this case. At the outset, it's easy to say that the issue on this appeal is easily stated and identified. The issue is, when is a settlement a settlement? The unique part of this case is...
Can I interrupt you? Do you mind? I have a bigger question, okay, that might have escaped your thoughts. It crept into mine, however, and I wondered about why an issue like this was litigated in surrogate's court, as opposed to, this is basically, a DJ action, okay? Declare the settlement reached. I guess I'm wondering whether or not this should have been in surrogate's court at all.
Well, all the proceedings were in surrogate's court.
Okay.
That precedes my involvement in it. And getting to one of my points, if I may, that it was the surrogate who in an order specifically encouraged the parties, saying in the strongest terms, I urge you to mediate your disputes.
But did that surrogate have any jurisdiction over this type of case? Again, it's a declaratory.
I'm sorry, I couldn't hear.
It's a declaratory issue. And that's not something that surrogates court has any jurisdiction over.
There were two proceedings pending in front of her at the time. And these settlements settled those proceedings that were pending in surrogate's court. So I would think it would be the surrogate who would preside over that issue.
So now let's go a little further on this. So now the issue is in contract interpretation. Is there a contract or not? And typically that's not what we see surrogates for.
I couldn't agree with you more.
Okay, so like I said, it crept into my thoughts that maybe this wasn't the appropriate place for it. But if you want to address that post, that's fine. If you could, maybe address that issue after, in a post argument submission. I would appreciate that.
I will certainly comply with that, Your Honor.
It sort of goes to a very important point of whether the surrogate had jurisdiction to.
Yes. All I can say today, standing here, is that these two settlements settled proceedings that were pending before the surrogates court. And the motion was made in surrogates court to declare these very proceedings settled. Now, I began by saying that the issue, and I think you have identified it, Justice Bannister, is when is a case settled? And the unique part of this appeal is you get to examine that question twice. And the reason you get to examine it twice is because Surrogate Mosey got it wrong twice. The first wrong was when she determined that a settlement offer made by counsel, signed by all counsel in very detailed form, which was given an acceptance date, which was accepted by the acceptance date, was irrevocable. Judge Mosey ruled that it was revocable. And that is contrary to all the common law decisions we've cited in our brief. The second way she got it wrong was, and I'll address this in a minute, the parties went back and mediated for a second time. And in this second mediation, a very detailed written settlement agreement was prepared by the mediator and signed by, I'm going to say, 17 individuals, including the lawyers for the parties and all of the trustees. Every one of them signed this settlement agreement. The last minute again, the respondent said, oh, no, this should be signed by the Attorney General. Well, it wasn't a condition, and the Attorney General on 2 occasions specifically said, we don't have jurisdiction to sign that agreement. We're not going to sign that agreement, and it doesn't affect us. The Attorney General wasn't a party to the agreement that was going to be bound by anything. So, Judge Mosey gives us her direction. The parties negotiate for 6 months. 6 months. The settlement offer is produced by counsel, sent to our counsel, former counsel, Mr. Manning. There is an acceptance date. Manning sends back the acceptance within the appropriate time, and then they say, oh, no. There was a caveat in the agreement. What? There was no caveat in the agreement. We recently learned that John Blair is named as a beneficiary of something called a provider's trust, and that Blair somehow committed fraud in this action. Well, the provider's trust was set up by Peter Tower during his lifetime. It was signed twice by his 2 daughters, who were co-trustees along with Blair, twice. The provider's trust had absolutely nothing to do with the settlement negotiations. And to this day, as we stand here, they still haven't identified what was the fraud that happened 12 years ago, and how did that fraud induce the settlement offer that they made in writing. Well, that's what fraud in the inducement is all about. You've got to do something to induce an offer, and there's a simple disconnect there. It's just not true. And factually, the idea of the provider's trust somehow being a block or a caveat is just factually wrong, because, as I said, it had nothing to do with the foundation. It was set up by Peter Tower during his lifetime for the benefit of 3 people who meant a lot to him and were close advisors and employees. One was no longer eligible. John Blair was named a beneficiary of that. That amendment was signed by Peter Tower and the three daughters in 2010, and not a word until 2022 on the eve of the acceptance date. It was nonsense. Well, one of the more incredible parts of this case is that after alleging these things about John Blair, they returned to mediation. This was a very skilled, experienced mediator, Mr. Modica. More months of mediation took place. And finally, Mr. Modica produces a written settlement mediation agreement. This written agreement, as I said, was signed by 17 individuals, lawyers for both sides, the plaintiffs, the individual parties, and all of the trustees, every one of them. All of the parties against whom the agreement could be charged, all of the parties who assumed rights and responsibilities under the agreement signed that settlement. The next thing we hear is, oh, no. The Attorney General has to sign this. Well, it wasn't a condition precedent. And Mr. Modica informed counsel that the Attorney General took the position that they didn't have to sign. They're not a party to the agreement.
Who added the signature for the OAG?
Excuse me?
Who added the signature line for the OAG?
Mr. Modica. It was part of his, he prepared the document, but it wasn't contingent upon the OAG, the document, the agreement itself. But Modica, and it's in the record, says on 2 occasions, I spoke to the Attorney General. They don't have jurisdiction to sign this, and it doesn't affect the agreement. And as a matter of fact, in December of that same year, the Attorney General's office wrote a very specific letter saying, we don't sign. It's not within our purview to sign these agreements. So what are we left with Judge Mantor? We're left with a document that, with Judge Mosey's encouragement, was agreed to by all of the affected parties. All of the parties to be charged. That's the concept in the law. The parties to be charged. They all signed it. What happened? They walked away again. So settlement number 2 was avoided. Well, this is
For a moment, can you get back to the question that I think Justice Bannister started with here, and Justice Smith also inquired about, is whether or not the surrogate has the authority to make this DJ proceeding in the first place. So
has to make the what proceeding? I'm sorry, Your Honor.
Declaratory judgment. Does she have the authority to do that? I mean, isn't it reserved basically to the Supreme Court?
It really wasn't a declaratory judgment proceeding, Judge. John Blair, through his counsel, moved in surrogate's court to enforce the original, the settlements, okay? It wasn't a declaratory judgment in the traditional CPLR declaratory judgment concept. It was a motion in the existing proceedings as captioned on the appeal to confirm the settlement. Now, surrogate's courts confirm settlements all the time. I mean, that's what they do.
But her order was a declaratory judgment, correct?
Excuse me?
Her order was a declaratory judgment.
Yeah, her order was really flawed.
But you're saying that it would have been a petition in surrogate's court, it would have had to start out as, right? And you're saying the petition did not seek declaratory relief?
No, the petition sought the enforcement of the settlement.
Which one?
Both. And that leads me to another point. As what I said, you got the 2 shots at this. It was to enforce the original settlement, which, by the way, is where she really is wrong on the law when she described that
She said I think she said it was rescinded before it was accepted.
Well, but she also said it was revocable, and she really misapplied the provisions of the general obligations law. The general obligations law doesn't require that a irrevocable settlement use the words irrevocable. It doesn't at all. That section is a so-called consideration section. The common law of this state is an offer is irrevocable by its terms, and counsel emphasized in the record that time is of the essence here. John Blair has to accept this global settlement, as he described it, by such and such a date. That's when the night before, on the eve of the acceptance date, they informed the mediator of this alleged John Blair providers trust fraud. So option number one is you settle based upon the first one. If you somehow determine that the offer was revocable and properly revoked, you really can't escape the consequences of the second settlement. And what I mean by that is, at the risk of being somewhat repetitious, this is a document signed by everybody. Everybody who assumes a right or an obligation signed this settlement. And what's really surprising to me and somewhat puzzling is that Judge Mosey seemed to go out of her way to not find a settlement, when it's generally true that I think most courts would, as she urged the parties in a written order to mediate, most courts encourage settlements and don't look for reasons why it shouldn't be settled. So the remedy here, it seems to us, is A, you enforce the first agreement, the first proposal. Now, there's a distinction between the two. One is an offer, and the other is a contract, okay? You enforce the first offer as being accepted, or if you deem it revocable, then you're left with the second one, for which there is no answer, for which there is no escape. The Attorney General is not necessary to enforce that agreement. And that's what the Attorney General said, and that's what I think the court should enforce. One of two. It's a unique case, guaranteed. And Justice Bannister, I will address in, I assume, letter form or some submission, the issue that you raised as to the jurisdiction of the surrogates court.
Thank you very much.
Thank you. Thank you for your time.
Counsel, you know what we're going to ask you. Let's start with the last question that Mr. Sure. Sutton.
In my view, this really should have been filed as a motion, because it was a motion to enforce a purported settlement. And it was a settlement of the two actions before the court. And so that court appropriately could and should have decided that issue. The fact that it may have been captioned as a petition, or the fact that she said it was a declaratory judgment, it really was a motion to enforce a settlement, which courts, whoever the court is handling the matter, routinely decides. Good morning, may it please the court. David Kiko for the trustees of the Peter and Elizabeth C. Tower Foundation. Sorry, my throat's a little bit off today. We contend that the surrogate did not abuse her discretion in finding that there was no settlement of this matter. As you've already heard, and I know you from reading the papers, there purported to be not one but two different settlements, and that standard contract law, which is fully developed, will decide this issue. But I'd like to start off with the first purported settlement, which was derived supposedly from an October 28, 2022 proposal. The proposal was made to the mediator. It's in written form. There are 5 independent reasons why this was not, in fact, a settlement. The first one, it was withdrawn before it was accepted. The contention is that, in fact, and there's no disagreement that it was resolved, that it was withdrawn before it was accepted, because it was Settlement didn't say it couldn't be withdrawn, which is the key thing to saying it's irrevocable. It just simply had a deadline. And the question is, does putting a deadline saying it will expire on a certain date mean it's irrevocable? General Obligations Law 5-1109 makes clear that that is not sufficient. What it says is that when an offer to enter into a contract is made in writing, signed by the offeror or his agent, which states that the offer is irrevocable, there is nothing here other than an end date, which indicates that this offer could possibly be irrevocable. And in fact, all the case law cited by both parties do not find the mere mention of a date makes a settlement agreement irrevocable. There has to be something else, saying, I will not withdraw it. There have to be other papers. And again, saying that this is irrevocable. And we explain that in our brief, and I'm not going to go through that. There's a second reason, and that is that the proposal was deemed by the mediator, or the parties, the other side, we're not sure because we only communicated with the mediator. There was a series of questions that were asked. And our client on November 7, responded to those. And we had a series of responses clarifying the offer. Part of that clarification was, we understand and we want assurance that there is no other compensation that Mr. Blair received from the Tower family or the Tower entities. He had made a representation during the course of these negotiations that there was nothing else. The response came on December 10 in writing about all these clarifications and including the caveat. And it said, oh no, in fact, there is this provision in the so-called Providers Trust, which Mr. Blair himself had drafted, giving himself a gift, which of course is a violation of Rule of Professional Conduct 1.8. The Providers Trust, though, is not necessarily the key, because it says there will be this gift over time, which may be by way of an annuity. What it said is that Mr. Blair himself, from his son, it turned out, had purchased this annuity. And not only, well, although the Providers Trust says the annuity or the payments will not start on the later of the time Mr. Blair turns 70, and he has to, in fact, be 70 before he has to continuously serve as trustee through 70, or he ceases to be a trustee of the foundation. It turned out that he had already started, he turned 75 in August of 2020 and started receiving the payments from the annuity that he had purchased. The problem is he served until trustee until April of 2022. So again, a clear problem here. That is the fraud that was perpetrated on us. In addition to that, this agreement was not, the amendment to the Providers Trust was not enforceable. Why not? When you form a trust and then you amend it and you change who the beneficiaries are, all the beneficiaries have to sign. A remainder beneficiary was the foundation, because if any of these gifts lapse because someone didn't earn it, or they couldn't for whatever reason, an annuity was purchased and they died before the annuity was used up, the foundation was supposed to receive that. The foundation never signed. Mr. Blair, as an attorney, clearly must have known that. The other piece of it is that the foundation was completely cut out, which again, no knowledge of that. So again, the caveat was not satisfied. Clearly they had a right, therefore the offer couldn't be accepted because that condition was not met. And again, that's a problem. The third reason is that if there is a mistake made, so there are two unilateral mistake issues. The first unilateral mistake is if you make a unilateral mistake and you're prejudiced, and the other side can be brought back to the status quo, which clearly Mr. Blair could be, with status quo was there's no settlement, then in fact there is no deal. So what was the prejudice here? The terms of the settlement proposed were based on, even though we fired you, we're going to agree, if you step aside and get rid of you, we will make these payments and we will reimburse you for some of the expenses that you incurred in connection with this litigation. The problem is that no one at the foundation side realized that Mr. Blair was getting all of this money in the meantime. And in fact, the second offer, which is the second supposed settlement, which Mr. Modica generated, reduces the amount by 300,000, which is the value that was calculated that this annuity represented. So again, clear prejudice can be returned to the status quo. The fraud is, obviously I've already reviewed that, which is again a mistake plus misleading the other side. It doesn't have to rise to the level of fraud, but you mislead the other side. You know that they're relying on you. And in fact, you allow them to do that and you go forward. That here was clearly that there was no.
Make that argument below? Was that argument from the circuit?
Absolutely, Your Honor. And in fact, the issue is specifically, well, the surrogate specifically mentions Surrogate Mosey. I'm not reaching the fraud issue, but the issue is these points are all outlined in the affidavit of Jennifer Flannery, which is repeatedly in the petition. Sorry.
Jennifer Flannery's role?
She was one of the attorneys who participated throughout the settlement negotiations, so she had firsthand knowledge.
Did she represent a party?
She represented the trustees, as do I. She was co-counsel with us. And Your Honor, I might add that in the case when you are seeking to uphold a judgment, even if the argument wasn't made below, if it's subsumed within the facts and you logically can understand it would be made, you can make it on appeal. And then the final issue is that, as we contend, no time on this, there's a waiver that obviously Mr. Blair, in deciding to continue and have the parties go through with further negotiations. So it's the same mediation, it's not a new mediation. The mediation resumed and we talked for another series of months. You waived the right then to argue that you already have this other settlement. So let me turn to the mediator's proposal, which was made on April 11, 2023 by Mr. Modica. So the key thing here is, again, there's no direct communications with the party. So Mr. Modica is going back and forth on all these things, including this. So he draws up this proposal. And there are 4 reasons why each independent, why this one is not binding either. The first reason is, that it was clear that a precondition of there being a settlement was that the Attorney General had to agree. The Attorney General, it's mentioned in the
Attorney General has declined to be a party to this, declined to sign, and also claimed that they have no jurisdiction to be involved in this. What do you say about that? We understand that there was a line for them to sign.
So the Attorney General is the one that hosted the first of the mediations. At that, they said, we will be approving the settlement. Later on, they say, well, we don't have a jurisdiction to approve all of the settlement, only a portion of it. It was still understood, and it was always a condition, and I'll review that in a second, that they would be party to whatever the agreement was. That was vital to the trustees. And why? Because the trustees were settling what they considered to be 2 frivolous actions that were brought by Mr. Blair. The first, a construction action to construe the indenture, which didn't require any construction. And in fact, that's one of the reasons he was removed. The second was his removal, which again, there are multiple reasons. And indeed, the position of our clients is Mr. Blair should be disbarred because an attorney cannot do all these different things, but I'm not going to review that right now. It was said repeatedly throughout, and again, the Attorney General was part of this. In the first proposal that our client made before the first mediation, immediately beforehand, which was in May of 2022, explicitly, the Attorney General must be a party to this settlement. That was repeated in the August proposal made by us. The Attorney General must be a party. It was again repeated in December of 2022 in our proposal, saying the Attorney General must be a party. In Modica's own draft of his proposal, yeah, there was a signature for the Attorney General. And again, the parties didn't disagree. I'm going to put my glasses on so I'll get the date right. The parties didn't disagree.
Do you disagree that the Attorney General turned this away and said, we don't have to be involved in this, we don't want to sign this?
No, the Attorney General did not say we don't have to be involved. If you look at their December 22, 2023 letter to all the parties, what they say is
we're reserving all the rights. You want to go forward with this settlement. We reserve our rights to object and to investigate. So they were absolutely not washing their hands. And that's the whole problem for our clients, saying, we don't want to go forward and pay this man that we think is entitled to nothing, that the Attorney General had urged us to settle on these terms and then backed away and changed their mind. We don't want to be put in that position. We then, and the reason that the Attorney General has set forth in our papers was saying that is, this is expensive. Mr. Blair is costing a lot of money. You're a charity, which we understand. You shouldn't do this. We're actually seeking money back from Blair. Anyway, so on December 14, Mr. Modica acknowledges that he needs the agreement of the Attorney General. And that's an email. Sorry? Fine. And then I go through it. It's repeated over again. It's repeated on April 15. It's repeated on April 18. And our claims. Yeah, sure. I'm sorry. I will quickly move on to the next reason. The next reason is that there was no meeting of the minds. So in order to have a settlement, basic contract principle, you have to have a meeting of the minds. Even assuming that Mr. Modica, as our opponent contends, did not properly explain that this was a condition of the settlement that the Attorney General had to sign, even by the signature line. Given the fact that our client had made clear, reported repeatedly to Mr. Modica, none of which is disputed, that that was a condition from their mind, it doesn't matter that Mr. Blair was confused or his side was confused, although they were not.
Ask maybe an obvious question that I'm.
Yeah.
Is what was the Attorney General's interest in it?
Because this is a charity, so the Attorney General was a party to all these proceedings and has actively participated. I'm not going to say, they have to be cited, and they are made a party, and they were a party, and they've actively, they filed papers in both of these proceedings. They've argued before this court in connection with an appeal of whether Mr. Blair should be reinstated. So they are an active participant.
Right, but it's not unusual for the Attorney General to be noticed on a case like defending a statute or something, and then they choose just not to go ahead.
That is true, but here.
You're supposed to do that if, wait forever for them, or?
No, Your Honor, this is different because here they have actively participated. They actively participated in the settlement discussion.
So why won't they sign?
I don't know. I would say it's political, and it's all to horse the record. I have a strong view of that, but it's all to horse the record. If you want me to speculate, I'm happy to do so. But
Explaining why they refused to sign.
there is nothing why they declined to sign on and then reserved all the rights to come back and challenge it. No, there is nothing specifically in the record on that. So and I'll be quick. So the other reason is the mediator conditions. One of the mediator's conditions were not satisfied. So condition number 2 of his proposal is that Blair has not gotten any more money. He has now disclosed everything, and he will represent to that. What we found out afterwards is there was something called the Peter Tower Living Trust. That trust, under its terms, Mr. Blair was one of the trustees. Under the terms, the trustees were required to close it in 2018, some 5 years earlier. What we found out afterwards is Mr. Blair was holding on to $150,000, 2/3 of which belonged to the foundation, and had been paying himself commissions throughout, even though he had said during the course of the negotiations, I've waived all my right. That was found afterwards. Given that, even had we accepted it, we would have then the right to say, you cannot comply with the terms of this proposal. Again, it's condition number 2. The other one is, of course, mistake and fraud. That relates to this provider's trust. He is again, after the first go around, assured us, I've told you everything. It turns out this other thing appears. And again, a mistake. We were offering him money, and it turns out yet again, he's been receiving more money.
Do you feel you know now all the money that he's received?
We actually, Your Honor, we have been asking, one of the conditions of the agreement was that he would finally turn over the records. As you probably know, under Rule of Professional Conduct 1.16G, when you fire an attorney, the attorney has to return all of the client files. We only got the last of the files 2 weeks ago. So I don't know.
So you may soon know when you go through those records exactly.
Whether there's yet additional monies. That is correct.
And hopefully that might mean that there could be some something you could do with knowing everything.
Yes, Your Honor, but clearly we were in a position where we didn't, that we kept on finding more information, and I very much appreciate your indulging me and allowing me the additional time and being very patient, and respectfully request that you uphold.
So you sent in a post
Of course, Your Honor.
submission on the one issue only.
Sure.
Okay.
Would you prefer that we both do it
I
simultaneously?
would, and maybe 1 week.
Very good. We will of course do
That's
so.
agreed. With,
1 week?
1 week.
Yes.
Simultaneous.
Yes, we can e-file it, Your Honor.
I guess that's fine. Yes.
We'll be happy to talk to we'll be happy to talk to the clerk's office and find out what's the best way to do it. Thank you, Your Honor.
Thank you very much. Case number 1003 is submitted. Case 1004. Do I have somebody? Okay. Okay, good morning.
Good morning, Your Honor. May it please the court. My name is Matthew Gordon, and I represent the plaintiff appellant Deutsche Bank National Trust Company as trustee, the lender in the underlying foreclosure. The sole issue before the court is the lender's standing to foreclose. I'd submit that the trial court erred by disregarding the clear evidence of the lender's standing, which is contained within the record, and by failing to disregard and instead unquestioningly adopting the respondent's baseless challenges to an assignment of mortgage, which the respondent lacks standing to even assert.
Counselor, let me ask you a question as a starting. Maybe the most important question, one of the most important questions, is that the note itself. Did Deutsche Bank or whoever the plaintiff in this action, did they have possession of the note?
Yes, they did have possession of the note at the time.
Did they have it at the time of commencement? The original note, it's not the copy of the note, they had the note itself.
That's correct.
Okay.
They did have possession of the note. Yeah.
Okay.
But the issues on this appeal are largely relate to the assignment.
Go ahead.
All right. So contrary to the trial court's determination, the evidence in the record clearly established the lender's standing, both as assignee and as holder of the subject note and mortgage at the time the action was commenced. And the respondent failed to raise any question of fact with respect thereto. First, with regard to the lender's prima facie standing, it's well settled law in New York that in a mortgage foreclosure, a lender can establish its standing where it's either the holder or assignee of both the note and mortgage at the time the action is commenced. And here, as you were alluding to, the lender established its standing both as assignee and as holder of the note and mortgage. First, there is a lot of case law in New York where the lender attaches the signed note endorsed in blank to the complaint that's sufficient to establish standing. I recognize that it's not unanimous throughout the state. However, that was the case here. And there was also, and the trial court alludes to this in their order, that there had been a prior motion for summary judgment where an affidavit was submitted by the loan servicer, which alluded to possession of the loan as early as 2 years before this action was commenced.
Right. And in this particular action, though, the court indicated that it appears as though the plaintiff has abandoned the argument it's entitled to standing based upon physical possession of the note. And I think the judge's claim was that there was a copy that was attached, and then here in the third department, we don't accept that fact that it's a copy that's attached, while versus the second department would accept that.
Yes.
Endorsement in blank.
Yes, and I understand that, and that's why I say that while we did attach it to the complaint with the endorsement in blank, we didn't solely rely on that, and that the court does allude to this affidavit that was submitted by the loan servicer attesting to possession of that note as early as 2 years prior to the action's commencement. So we relied on both the attachment to the complaint and the fact that the trial court acknowledged the servicer's affidavit.
Well, the court's saying that was a copy, therefore, the third department says a copy's not good. So that's why they said you abandoned it.
Sure, right, I understand that.
Okay.
I don't agree with the trial court's holding, especially in light of the affidavit from the loan servicer attesting to physical possession of the note. So I understand that while the court may have found that attachment to the complaint
Right.
wasn't sufficient.
And they indicated they reviewed the records. They made their business record exception affidavit, basically stating that I've personally reviewed the records, and we have the actual note and mortgage in our possession.
Yes.
Right. Okay. Go ahead.
I would note that this was submitted on a prior motion. It is actually not in the record on the current motion that's before the court.
Right. To me, that first action really doesn't hold a lot of weight, but go ahead.
Understood. But with regard to the assignment, which is the other way that the lender established its standing, New York law is clear that a written assignment of the note and mortgage is sufficient evidence to establish standing in a foreclosure. Here, the assignment of mortgage, which is in the record at pages, I believe it's 378 to 379, it clearly evidences that the lender standing as the assignee, because it specifically states that it assigned both the mortgage from AmeriQuest Mortgage Company, which is the original lender, to the appellant, and expressly states that it assigned the mortgage together with the note described therein.
That was City Financial assigned that mortgage, right?
So City is the power of attorney on behalf of AmeriQuest Mortgage Company. So you'll see that they signed it as attorney in fact for AmeriQuest Mortgage Company, which is the original lender. So the court really focused in on the fact that it was executed by an attorney in fact rather than the lender specifically, and really dove into that and took issue with that. But I would argue that the trial court really erred in questioning the authority of City Residential to execute the assignment of mortgage, because New York UCC 33071B expressly provides that unless it's specifically denied in the pleadings, a signature on an instrument is deemed admitted, and when the effectiveness of the signature is put in issue, the signature is presumed to be both genuine and authorized. And there has to be evidence put into the record disputing that from the other side. Here, the respondent did not question the authority of City Residential to execute the assignment of mortgage in their answer. They do have a defense contesting standing, but they don't say anything about the authority of City Residential to execute this assignment of mortgage on behalf of the original lender. So the signature really should have been presumed to be authorized. And the court, there's even a case from the third department, Goldman Sachs Mortgage Company v. Mayors, which has nearly the identical issue here, where the defendant in that case was questioning the authority of some assignments, and the third department ruled that the trier of fact was required to find that the assignment of mortgage was authorized in the absence of any contrary evidence. So I'd argue that the trial court really got it wrong here, and what
about the trial court alleging that, we're talking about this assignment, the trial court refers to, I think, page 374, which is paragraph 6 of the assignment of mortgage, which basically says the assignment of mortgage or deed of trust and the related mortgage note in connection with the repurchase of the mortgage loan secured and evidence thereby. He's indicating that this is not a repurchase, therefore they don't have the authority to do so. What's your response to that?
Right, and we don't argue that this is a repurchase. What I do argue is that this was the trial court kind of unquestioningly adopting the respondent's argument while not paying heed to our own argument, which was that paragraph 6 is not really applicable here. We claim to have that the power of attorney grants authority under paragraph 8 of the power of attorney. And paragraph 8 of the power of attorney granted City Residential broad authority to substitute in the appellant as the mortgagee and the beneficiary of the loan in accordance with terms of the pooling and servicing agreement, which is in the record at, I believe it was page 161 is where it starts. And
I think that document, according to the lower court, was rather burdensome to read, and it was quite, long, and why should we have to look at that?
Well, Your Honor, totally understandable.
Maybe I'm paraphrasing.
We do direct the court to the relevant portions of the pooling and servicing agreement. So to save them the time of having to comb through the entire document. But I'll say the pooling and servicing agreement in conjunction with the mortgage loan schedule that we also submitted. Both of those documents kind of work together. The mortgage loan schedule shows that this particular loan is part of the loan pool that is governed by the pooling and servicing agreement.
Right, you're helping the judge out by basically, rather than having to review the whole thing, here's where reference to this particular loan that's in the pool.
Yes, so the mortgage loan schedule is really an excerpt. We removed all the other loans just for confidentiality purposes, but we left in this particular loan to show that this is part of the pool. And in terms of the pooling and servicing agreement, I direct the court to specifically page 161, which is the first page, it's the cover page, and it identifies the appellant as the trustee and AmeriQuest, the original lender, as the master servicer. I also direct the court to pages 200 and 239 of the record, which is the definitions of master servicer and trustee, so that we can see that that is formally defined within the agreement. And then beyond that, I would also direct the court to pages 245 to 246, which is section 201 of the pooling and servicing agreement. And on these pages, it kind of outlines the obligations of the different parties to the agreement, and it obligates the master servicer to assign the loan to the trustee. So the master servicer being the original lender AmeriQuest and the trustee being my client, the appellate. So
in the written decision, it sounds like what Justice Montour was pointing out. It talks about 200 pages, the court below. There's 200 pages, not enough time to read it, so I'm going to have a trial on it. And you didn't do what you're doing here. You didn't specifically say, take a look at page 161, take a look at page 2. Is that right?
Well, not exactly. So it's not contained within the record because I generally don't include memoranda of law, but we did actually reference section 201, not the specific language, but section 201 to the trial court, which is the relevant portion that outlines the responsibility and obligation of the original lender to transfer and execute and record an assignment to the trustee.
Can I ask one last question?
Yes.
In all, how long was it that the defendant failed to pay his mortgage or make any mortgage payment?
So the date of I have to look at what the date of default was. But it was several years, I believe.
Okay. Thank you, counsel.
Thank you, Your Honors.